Welcome back. This is Public and Private International Law, Chapter 9, Part 3. At the end of the last podcast, I left you with that task. So what did you find out? What are your preferences? What is the very best arbitration institution in the world? And what are the typical arguments for promoting arbitration institutions? Well, looking at those arguments and visiting those websites, you probably had the impression that every arbitration institution seems to be the very best. And each and every of those arbitration places seems to be the most attractive of all. You probably have discovered some typical arguments that are used to promote arbitration institutions and arbitration places. Let's take one example, the example of the SIAC, the Singapore International Arbitration Centre. The Singapore International Arbitration Centre is widely regarded as kind of a rising star in international commercial arbitration. And here we are on the SIAC website on the page that is aimed at answering the question, why SIAC? As a short answer to that question, the web page starts by modestly claiming that this is just where the world arbitrates. And just below, you have a whole list of arguments, and let's have this a little bigger. Top of the list, we have the argument that Singapore provides an independent, neutral third country venue. In addition, the web page claims that Singapore features a strong multicultural society with excellent legal and technological expertise, as well as language fluency. Singapore is also praised as a central location in Southeast Asia, with 6,600 scheduled flights a week to 320 cities. In terms of the legal environment, the web page points to Singapore's legislation on international commercial arbitration that meets international standards by following the UNCITRAL model law. Another point is that Singapore courts offer maximum judicial support of arbitration and minimum intervention in a view to grant parties full and consistent support in the conduct of international arbitration. A further promotional message is about excellent facilities and services to support the conduct of arbitration at Asia's first fully integrated dispute resolution complex with state-of-the-art hearing facilities. An important point, of course, is money. SIAC claims to offer its services at lower costs than almost any other major center of arbitration. Of course, the SIAC is just one example. Each and every arbitration institution finds good reasons for arguing why its services are more reliable, more convenient, more cost-effective, faster, more innovative, better adapted to the needs of the parties, and so on, and why the legal environment at its location is particularly arbitration-friendly, and why state authorities at its location are particularly supportive of arbitration. Let me shortly mention three other leading arbitration institutions. ICC, the International Chamber of Commerce, is the world leader in terms of case volume. The Secretariat of the ICC International Court of Arbitration handles around 1,500 cases at any time. ICC arbitration is based on the detailed ICC arbitration rules that are widely regarded as the gold standard of international commercial arbitration. What is characteristic for the ICC arbitration procedure is that there is a sophisticated quality management in place. ICC arbitration awards are systematically controlled by ICC experts before being communicated to the parties. The International Chamber of Commerce is headquartered in Paris, but ICC arbitrations can be conducted anywhere in the world. Many ICC arbitrations are also conducted in Switzerland, for example. However, there is also a genuinely Swiss arbitration institution. Switzerland is a traditional venue for international arbitration. Maybe you remember the famous Alabama claims case that was arbitrated in Geneva in 1872. We discussed the case in week 3. This was the first formal third-party arbitration in diplomatic history. Since then, thousands of interstate and commercial disputes have been submitted to Swiss arbitrators and Swiss arbitration institutions. As far as international commercial arbitration is concerned, originally there have been several cantonal arbitration institutions, namely in Zurich, Geneva, Basel, Lugano, Lausanne, and Bern, established by the local chambers of commerce, and each with its own set of arbitration rules. But in 2004, the chambers of commerce of Zurich, Geneva, Basel, Lugano, Lausanne, and Bern joined forces, adopted the unified Swiss rules of international arbitration, and established a joint arbitration institution, the SCAI, Swiss Chambers Arbitration Institution. In terms of case volume, Swiss rules arbitrations are significant, with around 50 arbitral cases per year. But there are still more ICC arbitrations being conducted in Switzerland than Swiss rules arbitrations. Another important part of Switzerland's arbitration business is the arbitration of sport-related disputes. This is centered around the CAS, the Court of Arbitration for Sport, based in Lausanne in this beautiful castle-like building. The CAS has been referred to in a decision of the Swiss Federal Supreme Court as the true Supreme Court of World Sport. In a next step, I would like to move on to the regulatory framework of international arbitration. There are 3 different elements to this legal framework at 3 different levels, namely treaties at the international level, legislation at the national level, and arbitration rules at the level of the arbitration institutions. All 3 elements combined form the regulatory framework of international arbitration. Let's start with the international level with treaties. The single most important treaty in the field of international arbitration is the 1958 New York Convention, whose full title is Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And according to Article 1, The Convention regulates the recognition and enforcement of arbitral awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought, and arising out of differences between persons, whether physical or legal. The Convention has a very wide coverage throughout the world. It has been ratified by 163 states so far. Let's go through some of the provisions of the 1958 New York Convention. Article 2 deals with the arbitration agreement. It regulates what is required for such an agreement and what are the effects of such an arbitration agreement. Paragraph 1 states the principle that arbitration agreements have to be respected by the states that are parties to the New York Convention. It says that each contracting state shall recognize an agreement in writing under which the parties undertake to submit to arbitration all or any differences which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not, concerning a subject matter capable of settlement by arbitration. Paragraph 2 defines more specifically what has to be understood by an agreement in writing. It states that the term agreement in writing shall include an arbitral clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. Paragraph 3 makes it clear that as soon as there is a valid arbitration agreement, the jurisdiction of state courts is excluded for all disputes covered by the arbitration agreement. According to paragraph 3, the court of a contracting state, when seized of an action in a matter in respect of which the parties have made an agreement within the meaning of this article, shall, at the request of one of the parties, refer the parties to arbitration, unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. Article 3 is the very heart of the Convention. It makes sure that arbitral awards are binding and enforceable in all the 163 states that are parties to the 1958 New York Convention. This is the principle that is established in Article 3, a principle that goes with some exceptions which are narrowly defined in Article 5. According to Article 3, each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon, under the conditions laid down in the following articles. In Article 5, we find a list of exceptions to the principle established in Article 3. This list is exhaustive. It is aimed at limiting potential reasons for non-enforcement of arbitral awards to a minimum. According to paragraph 1a, recognition and enforcement of the award may be refused if the arbitration agreement on which it is based is not valid. According to paragraph 1b, enforcement may be refused if the arbitral tribunal had not respected basic procedural rights of one of the parties. According to paragraph 1c, the enforcement of an award that goes beyond what was submitted to the arbitration by the parties can be refused. Paragraph 1d adds that enforcement can be refused if the arbitral tribunal was composed irregularly. And paragraph 1e declares unenforceable awards that are not yet final. Two additional reasons for refusing enforcement are stated in paragraph 2. Those two reasons refer to the law of the state where enforcement is sought. And there are only two such reasons. One, that the subject matter of the dispute is not capable of being arbitrated according to the law of the state where enforcement is sought. And two, that enforcing the award would lead to a result that would be incompatible with the public policy, the so-called ordre public of that country. Now, this requires more than being contrary to the law of that country. It must be contrary to fundamental principles of justice recognized in the country in question. It follows that a simple alleged violation of the laws of the country where enforcement is sought can never be a reason for refusing to enforce an arbitral award. Let's move on to the level of national legislation. Do you remember what we understand by Lex Fori in the context of litigation? According to the Lex Fori principle, a state court that is seized by a dispute will refer to its own national law with regard to procedure and also with regard to the private international law rules for determining the applicable substantive law, the lex causae. And this Lex Fori principle applies as soon as the court has established its jurisdiction. So we can say that the Lex Fori is defined by the location of the competent state court. In international arbitration, we have a similar phenomenon that is called Lex Arbitri. The Lex Arbitri is defined by the seat of arbitration, and it is relevant for the national legal framework of international arbitration and also for the competence of the state courts in the event that at some point of the arbitration process, judicial assistance of state courts is needed, or in the event that the final award is challenged by means of an appeal with the state court. In addition, the Lex Arbitri is also relevant with regard to the private international law rules for determining the applicable substantive law if the parties have failed to include a choice of law clause in their contract. In Switzerland, Chapter 12 of the Swiss Code of Private International Law provides this national law framework for international arbitration. I'm sure you remember that code, and you probably remember its basic structure. And here is what we are focusing on now. I invite you to follow me on an expedition across Chapter 12. And this is what you are invited to look for. It starts here with Article 176, referring to the field of application of Chapter 12 and to the notion of the seat of the arbitral tribunal. Paragraph 1 states that the provisions of this chapter shall apply to all arbitrations if the seat of the arbitral tribunal is in Switzerland and if at the time of the conclusion of the arbitration agreement at least one of the parties had neither its domicile nor its habitual residence in Switzerland. According to the next article, Article 177, paragraph 1, any pecuniary claim may be submitted to arbitration. Article 178 deals with the arbitration agreement that, according to paragraph 1, must be in writing by telegram, telex, telecopier, or any other means of communication which permits it to be evidenced by a text. Paragraph 2 adds that the arbitration agreement is valid if it complies with the requirements either of the law chosen by the parties or the law governing the subject matter of the dispute, in particular the main contract, or with Swiss law. According to Article 179, the arbitrators shall be appointed, removed, or replaced in accordance with the agreement of the parties. And according to paragraph 2, in the absence of such agreement, the judge where the arbitral tribunal has its seat may be seized with the question. Article 182 states that the parties may directly or by reference to the rules of arbitration determine the arbitral procedure. They may also submit the arbitral procedure to a procedural law of their choice. And paragraph 2 adds that if the parties have not determined the procedure, the arbitral tribunal shall determine it to the extent necessary, either directly or by reference to a statute or to rules of arbitration. Article 183 deals with emergency measures. It says in paragraph 1 that unless the parties have agreed otherwise, the arbitral tribunal may, at the request of one party, order provisional or protective measures. And paragraph 2 adds that if the party concerned does not voluntarily comply with these measures, the arbitral tribunal may request the assistance of the state judge. According to Article 184, the arbitral tribunal shall take evidence. But if the assistance of the judicial or administrative authorities of the state is needed to take evidence, the arbitral tribunal, or with the consent of the arbitral tribunal, a party may request the assistance of the judge at the seat of the arbitral tribunal, who shall apply its own law. And Article 184 says that if any further assistance of the judicial or administrative authorities is needed, the judge at the seat of the arbitral tribunal shall have jurisdiction. According to Article 187, the arbitral tribunal shall decide the case based on the law chosen by the parties, or in the absence thereof, based on the law with which the case has the closest connection. The parties may authorize the arbitral tribunal to decide ex aequo et bono. According to Article 189, the arbitral award shall be rendered according to the procedure and in the form agreed upon by the parties. Article 190 makes it clear that the award shall be final as soon as it is communicated to the parties. The award can only be challenged, A, if a sole arbitrator was designated irregularly or the arbitral tribunal was constituted irregularly. B, if the arbitral tribunal erroneously held that it had or did not have jurisdiction. C, if the arbitral tribunal ruled on matters beyond the claims submitted to it, or if it failed to rule on one of the claims. D, if the quality of the parties or their right to be heard in an adversarial proceeding was not respected. And finally, E, if the award is incompatible with Swiss public policy, ordre public.